Good day. So seriously, all kidding aside, do any of you worry, to finish our discussion from the last time, about how you'll continue to be a lawyer and a human being? Or do any of you have any thoughts on how you would align that? I mean, your obligations as a lawyer are certainly at times highly inconsistent with what most would see as being a decent human being.
I'm not doing criminal defense.
Huh?
I'm not doing criminal defense.
Well, and I know that's one easy way to start to think about it, but honestly, just to throw it out there, there's a lot of civil cases where you're in, that I've been in, that the people may not be very nice. What has happened is not not just nice. I mean, it's downright mean, and sometimes, especially in the large cases, the lawyers and the parties start to act like the lowest form of life. So it's not, I think sometimes we think the criminal area, it's a lot more cut and dried, and it is, obviously, to some extent, if you approach it one way. But the civil cases, sometimes you get there and you realize, uh-oh, this is not what I thought it was, and not who I thought they were, and it's not what happened. And civil cases sometimes are brought for very meritorious grounds, and other times they're brought to punish and to deter and to be used to bully others. I mean, you know, I've seen a lot of employment cases where the company has a modest case, but what they do is they bring so much power to the table, they're attempting to crush the former employee and prohibit them from working anywhere else for a significant period of time, which for most of us, if you were forced to be out of work for 3 months, 6 months, a year, you might as well flush whatever financial future you might have had. And my guess is for most that would affect them personally in a significant way as well. But it's pretty routine when we attempt to oppose, when someone tries to enforce non-competes, that it's not all about the merits of the case. It's about making sure all the other employees know they're going to toe the line in the future and not dare to think about this. So this notion that if I stay away from one part of a case, like for instance, okay, so let's stay away from those. You all, what's your plans on divorce cases? I mean, no? Huh?
Not interested.
Well, you know, so now we've carved out both criminal law and divorces, which are two pretty significant.
I'll do divorces.
Oh, you'll do divorces.
Yeah.
You nod your head like
Job
this. Oh, yeah. It is job security, Aaron. There's no doubt about that. But again, let's be realistic. Sometimes the kids are used as pawns. Sometimes you're fighting. People want to fight about. They're not fighting about it. They're about things. They're fighting about the anger and the hostility and the heartbreak and everything else. And it's wasted money, and it's sometimes oftentimes mean-spirited until the money starts to run lower. But what about that? I mean, I've had fathers, in essence, virtually abandon their children because as they saw it, if they didn't have much contact, they should pay less. Now, that's obviously not true. I've had people give up their rights as parents so that they wouldn't have any obligation to further support the child. I mean, that's pretty, huh?
That's their option.
But that's the parent you represent. I mean, I can't be the parent you would ever want to be.
No.
No?
Is that a big factor where you work? Like you said, if you're in a firm and you're the low man, you have no say.
Well, and that's realistically, I mean, that's the thing. As we start out, I obviously can pick and choose what I want to do and who I want to do it for these days. It's not the case when you start out. It's not the case at all. As Jim points out, I was low man. I would not have taken that client I told you about, not on a million years. But, she was just mean, It wasn't like she was lying. She laid it all out there and just was very ugly. She actually wasn't the worst. But Jim's point is right. You're the low man. You're taking what they give you, and they may not be doing things horrendously immoral. They just are not. They're not the type of people you would have a drink with, or you would associate with, or certainly would have in your house. and now you're doing things for them that you would never do for yourself, and certainly you would never want your children to do. But that's our job. I mean, so I'm just wondering, have you given that thought? I mean, we can sit here in a classroom and say, yeah, that's my job. I understand that's my job, but I represent people that I... Go ahead.
Well, I've been a social worker for 20 years, so
True.
I have worked for the state, I've worked for private agencies, I've worked for somewhere in the middle. And when I have the same mindset that I'll probably have as an attorney, I'm just not going to like some of them, but I'm going to do my very best for whatever the situation is. And I think the only people that I don't ever want to represent would be pedophiles. Let someone else do it. But I don't know, as long as you're not, for me, as long as I'm not compromising my deeply held beliefs, the periphery can we can work with that. And I don't know.
I hear
I
you.
don't know yet where that line is going to be in the sand.
Yeah, but okay, and that's the last point is something I really I need you to start to think about, because you guys have to figure out where that line in the sand is here, because when you leave, if you don't have that line, you're going to be asked to do things that you just would never have guessed. And you say, my deeply held beliefs. Is it as does it need to be as deep as that? Because I'm going to give you an example. This is a terrible example, okay? Because you brought up that you were a social worker. My wife did a lot of state intervention cases. I did not, but I've had a handful, and a handful of significant cases for the families. I hated you guys, and I'll tell you why. I'm going to tell you why. Not that it wasn't, well, the cases I was involved in were not the cases my wife was involved in, the types of cases she was involved in. Mine were rather unusual. They started out as foster children and stayed there for years, and then the state wants to take them away, or they wanted to take them from a home where they had been for years and then split siblings up, okay? I have 3 brothers and a sister, okay? To me, okay, maybe mom and dad had problems, but we always had each other. And that's the way I would think many families are, and especially with some of your cases. I don't see how that's better to sort of cast them into the wind separately. And so oftentimes...
I agree with you. It's not in their best interest.
But you had a job to do there.
Well,
right? And there were times, who's going to take those 5 kids over there? There's no family that's going to take those 5, and they don't even know those 5, right? But right, is there a family that will take 5 in, 3 in?
So that's where you go the extra step.
And they'll take Charlie because he's the baby, but they're not taking the rest of them. No, right? That's where you go what? That's
where you take the extra step.
What's that mean, the extra step? Because you felt mandated to intervene, but the solution is worse than the cure, isn't it, at times? And I guess this argues more for you guys to be better advocates, because even someone with a good, white hat on, at times, is not the way I saw it. I had twins they wanted to separate.
Well,
I'm a twin, too.
Why? Because they couldn't find places for them?
No, I'm not even going to go into the whole story, because these kids had been with my clients for a year and a half at this point.
Are you talking about the state? You're talking about the state workers, right?
No, I'm talking about, we started with, criminal cases. I'm never going to handle a rapist or person who deals drugs at the school. What I'm trying to convey to you is, in cases where you almost would think, well, you should easily be able to tell who's got the white hat and who's got the black hat on, it's not so readily apparent. And that's what I'm saying is, I'm not so sure it has to be, where I tip over the edge. That I think at times you're going to be tested and say, well, geez, I really don't even want to do this in this case. I don't want to. I don't think I've got the right client. But Jim points out you don't have a choice at that point, do you? So how do you go to bed at night? Or you just, I mean, seriously, how do you think that all affects you? Because at some point you've got to figure out what your boundaries are. How your own sense of right or wrong, your own moral compass aligns with being the lawyer. Or are they separate? Go ahead.
Maybe I'm wrong. I mean, it doesn't, but my deep-held belief is that everybody needs representation. So, I mean, I don't know if I've been in that situation, but I don't think it would really bother me. I mean, there are obviously certain things. You know,
So rapists, drug dealers, liars, cheaters.
I don't think it would bother me. They're going to
Children
get representation
abusers.
from somebody. You know what I mean?
So they might as well have you.
Right.
And that's fine.
I believe
And so at the end of the day, Mark, when you go in, put your head in the pillow, it's off to sleep we go. You don't think about the carnage left in your wake?
He says that now.
But I'm wondering, and I hear that because I think it is relatively easy to say it here. But I mean, what do you think?
I think you gotta leave your work at work. It's every job. Most jobs are like that.
But this one has a moral compass.
Huh?
I won't do that.
You can't do it, Sid. Go ahead, Evan. Jim's going to leave his work at work, have his bourbon and his cigar, and sit back in his big fat chair and say, I paid the bills today.
Yeah, exactly.
Well, listen, and honest to God, I can make that sound, oh boy, that's cold. But you do have to pay the bills at the end of the day, don't you? I mean, because if you don't, then your family doesn't eat, and you don't sleep inside during the winter.
Yeah, I can't say to your mortgage company, I can't pay this week because I want to represent a pedophile. They said, you should have represented him because now you lost your house.
They're not going to listen to your moral compass. Go ahead, Harold, and then Jonathan.
I agree with Mark. It's not that we believe that this person is innocent or that they're a good person. It's just that because of the job that we have, the system has to work. And for the system to work, even the bad guys, the terrible people, has a representation.
No doubt, they should get due process, and it's not that they're innocent. I mean, don't fool yourself about that. The question is, can the government prove that they're guilty beyond a reasonable doubt, right? I mean, let's be realistic. You're not you're saving a lot of innocent people if you're doing the bulk of your work as criminal law. You're maybe protecting their rights and opposing the enormous power of the government to find someone guilty. But you're not doing God's work out there, right? I mean, let's realistically, right?
That's the clientele you're gonna get.
Well, that's why people turn to crime, right? I mean, I'm not trying to be overly cynical, but you realize this, right? You're not representing innocent people. If you're lucky, maybe 5 out of 100, and I think I'm going long on 5. No, right? Don't you guys? I'm not being overly cynical. Guilty is a question of can guilt be proved beyond a reasonable doubt. We understand the term innocent has completely different an understanding to it, right? They're not innocent. They may not be guilty beyond a reasonable doubt. But those are different jobs. You all know that, right? So you're not fooling yourself that. I mean, because really, it's fun. It's nice. You know what? It's actually scary when you actually do get an innocent person, right? You really do get someone who's either getting railroad or wrong place, wrong time. And now the stakes are high and important. And now you really better do a good job because losing matters now. It does.
It doesn't.
It doesn't. Not if you recognize that everyone should get what they deserve. Hopefully even with your zealous representation. Because you didn't do it, right? I don't care. I'm going to try the case. I don't care. I'm going home to my own bed tonight with my own toothbrush, and I'm going to go to sleep. I don't care. I mean, I care. I would like to win. But what happens then when you really do find that person? And I think you should care. By the way, for that person, honestly now, do you care more or not? Or it's all just the job? I mean, did everyone get the same level, or do you work a little harder for some?
Maybe a little bit.
Oh, you do work a little harder for some?
Maybe a little.
Is that true? I thought.
Me personally?
Yeah, you personally. No, you speak for Masha.
Quite honestly, I think that subconsciously, it would be like you probably, unintentionally, but subconsciously, I think you would probably want the person to get a better result. But speaking to, I don't know what my man's name is. Jim. You kind of make it seem as though if you have any type of a moral compass, you're going to be eating beans for the rest of your life if you're a lawyer. Because it's like,
Could be.
it seems as though if we're not...
No, I'd like to think I have a moral compass, and I...
No, I mean, but it's...
I do just fine.
No, but I'm saying, like, you're making it sound as if, like, you know, you either have to be like this, like, you know, underhanded creature to, like, be successful, but I'm kind of like torn with the conversation where this is going right.
No, I don't want it to sound like you have to live out of a cardboard box
Right.
to still have some sense of who you are and your moral center. What I do think is we have to recognize is that will at times will be severely tested by your role as an advocate to represent people who may have no moral compass, have not, and frankly don't give a damn about yours, because you're not their clergy member, you're their advocate and you're their lawyer. So they will ask you to do things that you will be shocked at, and that's what I'm trying to say, is that you have to figure out where those boundaries are now, because you can't become part of it, right? You can be their advocate, you can be their representative, but there has to be a clear delineation of what you will and won't do. And that's what I'm suggesting, is that, because I do agree, I don't know, was Everald or who said it, but because once we're in, you know, sort of, that's where your moral judgments probably don't play a role.
So
You know,
can
go
I ask
ahead.
you a question? Have you, whether it was early in your career or what have you been faced with that time where a client that you were advocating for asked you to do something that you were kind of like, whoa, okay.
Oh yeah, I just say no.
What did
I won't do it. I'm not going to do that. I'm not going to falsify a document. I'm not going to put you up there to what? Oh,
Why?
that's
No, I didn't know what you meant by that. I didn't know
oh,
what you meant that.
agreed.
I didn't know you meant like falsify or something like that. I thought you meant like, you know, like.
Oh no. Okay, no. He's asking a slightly different question. Have they asked you to do things that you simply won't do? And what I'm saying is that includes virtually anything, if you think about what people might ask you to do. And so that's what I'm saying. You have an obligation to make sure you know yourself what you will and won't, because it's easy to get swept up in saying, no, I'm an advocate here and it's winning what we're about, because I've told you guys in Cipro that had me, the first person they're going to roll over when the rough water comes is you, and they're going to throw you under the bus. You're not family, you're not no one. And so you have to have your own clear markers as to what you're willing to do and what you're not. Beyond that, then the question is the question that I think you were answering, that I think that is really the bigger one. Is it really so easy to get that rapist off, or to work for the state and split a family up so that these kids are cast into the wind, or to represent someone and defend a company or an individual where they're clearly wrong? They have the resources to make it right, and it's cheaper to continue to litigate and fight than to take corrective action. I mean, that's what I mean. Is it just about wins and losses, or how does that part of it factor in? And that's the other part you were saying, is I think I'm not your clergy member, I'm not your financial advisor, I'm your lawyer, and as long as the bills are being paid within the ethical practice of law and Rule 11, I'll fight. And I'll fight until you say, don't fight anymore, or until you run out of money, because that's the deal. Go ahead. You were going to say something. Next to Jonathan, I can't remember your name, I'm sorry. Zainab.
So right before law school, I was working for a firm, and we were representing the county, and anyone that had tax delinquencies, we were basically foreclosing their homes and processing all the deeds. So on a weekly basis, I was making hundreds and hundreds of people homeless. Yes, they had valid reasoning for why they couldn't pay up, but after a while, I mean, after 6 months into it, I think it was wearing down on me. I couldn't do it. When we would see these people hear out their reasons, yes, they were not criminals. They did not have any bad etiquette or behavior when they would come into court, but just looking at them, hearing out their stories, it would just wear me down to work in that environment that I'm going home tonight, but I'm putting X amount of people out. And there was a moral compass there that I chose.
Well, it gets worse, doesn't it? Because you were working for the people that took these subprime mortgages at outrageous interest rates and forced these poor people who then didn't have the ability to pay the mortgage. So you really, not, right? I mean, that's the rest of that. That appears to be the rest of the story in some significant way. And so you do the foreclosure because it's a foreclosure. What's the big deal? Our foreclosure is a big deal because the stories, right? It's not a case. Someone's on the other end of the phone crying, sobbing. Or maybe worse yet, they're in your office. You got to be able to do something. Is that you're all relatively comfortable that's as easy as it sounds? Or no, I'm not, but I'll figure out a way to deal with it in a year and a half when I'm closer to the end. Go ahead.
I worked for a litigation attorney and I hated it.
Why?
The phone calls we get from the people with debt, crying, wives saying I'm going to lose my house. It was horrible. Because I know that a couple of years ago financially it was horrible. And a lot of people couldn't bring food to the table. So what I'm going to say, go to court.
But I mean, someone's got to represent them. And how many areas can you say, well, I can't do that, won't do that. I'll wait. I mean, you know what almost came out of my mouth is I'll wait till I represent the church. Well, you know. And that's not such a good thing either. Go ahead.
You know what I always think of when you talk about stuff like that is just like a moment where, like, let's say you're working late at night, and you have somebody that you really don't agree, like pedophile, someone that's just like, oh, despicable person, and you just by digging a little deeper, you find some hook that you could get them off on, like that maybe you could explain away if you didn't find it. You know what I mean?
Yeah.
And and then you just sit there like, geez, I could probably just forget I saw that, and you still get representation. Maybe someone else would have missed it, but like, do I file a motion and get them off scot-free? Like, that's the only thing. Like, I don't know why I always think of that like that. I mean, you might think of that later on. You know what I mean?
You might think of that.
A moment like that,
but if you ever saw what's the Robert De Niro movie with Nick Nolte? Cape Fear. And if you haven't seen it, when you want to think about Mark's route, you ought to see it because his client is Robert De Niro, and he doesn't take he chooses that Robert De Niro probably doesn't belong back on the street. And it's for a lawyer. It's a scary as hell movie. Very well acted. But can't you? I mean, you can't take a dive, can you?
Great.
No, you can't.
You can't, right?
You can't.
So you just work through whatever issues you have, whether it's the divorce or the foreclosures or the criminal case. Because once you're in, you're in. Do you give them any advice? Let's suppose you get your very best advocacy. At the end of the day, give them any advice? Don't be a jerk now. Huh?
Don't call me again.
Hey, you really want that? It sounds like you need the money. No? Don't call me again?
Isn't that
So it's a business. Business keeps getting sued. You keep winning. No, it's not sex discrimination, not harassment, no wage violations. So you represent the sweatshop. What the hell? That's a little annuity for you, right? I mean, do you really say don't call again? Or you say, hope to see you soon. No, you do, don't you? You hope to see them soon, don't you? It's that thought? Jim, Aaron's nodding her head. Jim, hope to see you soon, right?
I need dough. I gotta pay my mortgage.
Right? I mean, a bad client that you keep doing successful work for is a good marriage, right?
Come back.
What are you saying?
They always come back. I went once to the criminal court with a relative, and there was this attorney that even the judge was like, oh, you don't have an attorney? Well, go to that one right there. Like, he would take every single case. He did not care what it was, anything. He was just like, oh, yeah, here, here's my card.
Well, my guess is, those of you that are going to do criminal work, I mean, you're really going to sort of separate them out? Right? I mean, which ones won't you do? Right? Don't tell me, oh, the guilty ones, because then you will be living out of that cardboard box. So which ones won't you do? I mean, would you carve out rape, drugs? Are you going to carve out something, or
Yeah.
huh?
I think rape and drugs.
I think rape and pedophilia.
Rape and drugs, you,
No,
That's everybody.
huh?
I meant rape and pedophiles. Yeah.
Okay, but all the drug cases?
And murderers.
Murderers?
Jaywalkers.
So,
So Professor, is it really just,
Come on.
you're telling, you're going to say to clients, no matter what their crime is, listen, there's a letter of law that we have to follow, and I'll do my best to find a way to follow that law to your advantage. There's no promise that you're going to walk free. There's no, I mean, do you look at it that way?
well, I wouldn't quite have that conversation like that. Not if I'm expecting to get a check before they leave.
Maybe being that blunt and honest, listen, I'm not going to, mix bones with you. This is it. It's a serious situation.
Oh yeah, you're in serious trouble.
Yeah.
I think, you need representation.
Not the brightest moment.
Hopefully, we'll either be able to cut a deal or we can win a trial. But obviously, there's never any guarantees. But
But is that the compass you're looking for? Like, okay, I'm going to look at this person, like, how does the law affect this person?
well, but that's what we were looking at. That's all you care about, isn't it? Because that's what that dissent was talking about. All you as the lawyer care about is the law. You don't care about what's right or wrong. That's our jumping off point, right? You don't care.
Well, the judge that had the sole decision there, so why is he putting it on the lawyer? The judge had the sole decision to give that injunction or not.
Agreed. I'll give you a little guidance that I got in one of the cases that I had sort of mentioned with respect to Marsha, because it was very troubling to me. And then about halfway through, I said to my wife, I said, I'm not sure I've got the right side on this case. Okay, but when I have a case, I feel pretty strongly. I said, I'm not sure I got the right side. And I really wasn't, because as it turned out, I wasn't. I really wasn't. Okay? And she said, quite matter-of-factly, so I'll give you the same advice she gave me. She said, that's not your job. She said, that's not your job in this case. That's the judge's job. So you're supposed to do what you're supposed to do, and the judge will figure out whether you've got the right side or not. And that is what many of you are saying, is that and I was very tested of that case.
Just listening to your conversation, it makes me filled with anxiety, saying, am I going to be able to do this? Will I be able to keep my emotions in check and not say, you did what? No, in some outrageous motherly fashion, have a habit of doing. Because I can hear my granddaughter, who's 14, saying, Nana, you're going to be a lawyer? The minute someone cries, they got you. And I mean, it's really ringing in my ears, when I'm reading cases. I'm like, oh.
I don't think you have to be an emotionless and a dispassionate advocate. I think you have to be careful when you are. And the problem with that potentially is that there will be some cases then you feel a greater passion for than others, but at least when we look at the books and everything else, it says everyone's supposed to get the same effort. And I know the books say that, but in reality, I don't think that's true. There are cases, there are causes, there are things you'll do more for. And it's not that the others are getting less than an appropriate standard of care. It just does some cases over the course of your professional career that you are more invested in. And we could say that shouldn't happen, but as a practical matter, we are human beings. There are causes and cases and clients that we are more attached to than others. Doesn't mean the others don't get a very high level of care. It means that some you're gonna go above and beyond what you need to do, because that matters more. So I don't think you have to be dispassionate or emotionless. I think you've got to be careful, because they're not looking for clergy advice, right? They're not looking, oftentimes, they don't care what your moral compass says should or shouldn't be done. They're looking for a mouthpiece, and they're looking for an advocate, and even if they should go to jail, no one wants to go, right? So don't tell me the best thing for me to do is serve 6 months in jail. You go serve it first, and then we can talk. No, right? Then we can talk.
So is it the clients, when they come in, do they usually provide fabricated information, or is it attorneys?
Yeah, almost always. No, no, that sounds terrible. But and it's not fabricated. It's their view of the world through the prism of their eyes, okay? But it's not 100% truthful. Neither is the defendant's version of their events. They could think it is. People think that that's what happened. But there's the plaintiff's story, there's the defendant's story, and somewhere else there's the truth. That's the way it is. If I asked you about a fight with your partner, or a roommate, or wife, or whoever, you're going to give me your version. And it's not 100% truthful, because that's who we are. If I ask the other involved in that, I'm going to get a different story. And neither is completely accurate. That's why we have judges. That's why we have juries. So and that's where you've got to sort of hone your own sense of, well, how do I separate out here and find out what's really going on? And you know what? There's a whole other school of thought that as a lawyer, you don't want to know what's really going on. What you want to know is what your client tells you, so that you can, and what evidence supports it, so that you can present your client's case in the best possible light. I happen to like to try and figure out what the truth is, but that's absolutely not what 100% of lawyers will do. Because you tell me you killed him, now my hands are more limited as to how I can try this case. You give me a version of the events that I can sell, that you can sell, and now I can sell it. Now I have a better chance at selling it.
So are you like being willfully naive at that point, or is it usually like, oh, like you really think?
No, it's not naive. Willful blindness is what it is, right? That's from criminal law. I didn't know it is willful blindness. If you do that, right, you don't want to know. I like to know because I don't want surprises at trial. I'll deal with what the facts are and what the evidence that supports it. It's much, for me, I can deal with that much better than to be blindsided a month or a week or at trial with evidence that you never thought it would see the light of day. So to me, I'd rather know. But it's a decided tactic, especially in criminal law, is before you say anything, let me tell you what your options are here. If you killed him, it could have been in self-defense, but self-defense can only be this. No, seriously, from a standpoint of interviewing. So sometimes people will lay it all out before you hear a word, because once I hear information, then my hands are tied with respect to how the case can be tried to a greater extent. Now, certainly we could argue, are you encouraging perjury at that point? And I don't know how much of an argument there is if you say, okay, you can go to jail for the rest of your life without any chance of parole if you did it without a defense. Or if you didn't do it, then you might not go to jail at all. Or if you did it, and these are possible defenses that are available, then you might get off as well. So which is it? No, right? How many are you picking option A at that point? Not too many, right? And so, are you an officer of the court? Have you assisted with providing the court potentially with false testimony? Or are you just an advocate for a murderer? And listen, all I'm suggesting, because I don't want you to not eat, I don't want you to not take cases, and I do believe in due process and the right of everyone to have a lawyer. I'm just saying that I'm not so sure it's as easy as you sit here and think that. So then when your head does ultimately hit the pillow at night, that you don't start to see some of the carnage you've left behind. And I don't know, right? I just don't know. Like, could you have represented the church all these years, hiding decades of pedophilia? Decades of children abused at the hands of our own church? Because the lawyers were right in the thick of that as well, right? Someone's lawyers were making lots and lots of money all that time. What the hell? Could you? I mean,
sounds good. I represent the church.
No, but isn't that's almost worse than the pedophile priest to him or herself, isn't it? Because you helped perpetrated decades of this, And that's you. That's you. That's not the individual pedophile priest. That's you who gave counsel and comfort to the organization that they could hide this for decades. You all good with that?
I don't think any of us really have to worry because that's a big firm, senior partners. So,
and actually, they were often, I hear you, but they were oftentimes represented, they actually were represented by a relatively smaller firm that was for decades. And a family law firm, so it was all kept in a relatively close to the vest. So I mean, there weren't a lot of secrets shared in the rest. But Jim's right. I mean, they, for the most part, a pretty white shoe firm. What did you want to say?
Yeah, I'm trying to connect all the dots because if your client is talking a lot, criminal client, they're telling you under attorney-client privilege that they did it.
Yep.
They committed the murder. And then you can't withdraw because you're already representing them. You can't break attorney-client privilege.
Correct.
And share what they just shared with you. And you can't put them up on the stand and let them hurt themselves. So I'm seeing all the can'ts, but I don't see like a big...
Well, my understanding is you guys who have had ethics can help me with this. My understanding is you can put that person still up on the stand, and they can testify in the form of a narrative.
Yeah.
You just can't assist with the Q&A as it comes out, correct?
yeah.
So you can still assist them with their defense, and you're not obligated to withdraw. And so, and by the way, it's not just that. You're going to give an open, and you're going to give a close, asking that they find your client not guilty of the offense, right? Perhaps even saying they're in the wrong place at the wrong time, and accuse the police of misconduct, probably, right? That's ask where the DNA and the blood evidence is that would support this, instead of the sloppy police work. Right? I mean, it's not just putting them on the stand. You're gonna let it all fly, such that someone could see your performance and think that they might actually not be guilty. But you know better. And then you're going to put them on the stand for the final act so that they can get up there and sob and talk about their bad childhood and say they never did it, and all of that, right?
I don't think you can put a criminal on the stand
Well, why not?
because there's a good chance they could get crushed on
Well,
cross.
okay, agreed. But first of all, it's their choice whether to
Yes,
testify
yes.
or not. And some of them obviously think they're smarter than they are, or they wouldn't be where they're at. And so it may well be that despite your admonition, they want to testify. And so they could get crushed, but listen, well, would you put Aaron Hernandez on the stand? Well, probably not, because what I'm thinking about, probably not, okay? I'm thinking about someone with no criminal background, but they snap. So there's no prior record coming in. I got neighbors in the community who, if have to, can talk about how peaceful and what a nice person they are, but they present themselves well. I always think that the jury, even though there's they don't have to testify, the jury likes to hear the story. There will be times where you'll put them up, even though you have information that you're worried about on cross, obviously, but you think that they can sell the story best on behalf of themselves. And at the end of the day, they may say, no, I want to tell my story. And so you don't get the final word on that either. So I just want you to give it a little more thought as to where your boundaries are. Because to answer her question, you might know. He might have told you they did it. But they're still getting all of your talents. Right?
But how does that tie your hands if they tell you something?
Well, because you can't assist the questioning by Q&A. You just have to put them up there, and then the advocates likely know how this is going to shake down. You might have even tried to withdraw, but withdrawing simply because they've done it doesn't mean anything. That's not a sufficient basis. The fact is, if they're going to perjure themselves, but you can't assist with it. But this is the problem: is they want to tell a story that isn't true.
So, Professor,
And it isn't. Well, all you know is it isn't because they've told you a different story. But the fact is, you don't know how truthful that was. Go ahead.
So you would say something like, Mr. Benara, you have a statement you'd like to make to the court? Is that how you'd let them say?
Tell the court what happened. You know, and it's normally an objectionable question because it calls for a narrative. But you're not supposed to assist with the perpetration of perjurous testimony at this point. And by the way, again, you guys don't just separate out the criminal cases, because civil cases people lie all the time too. So my experience is in civil cases they lie a lot. You know, people don't want to go to jail. They also don't want to pay out any money, much less as the numbers escalate. People lie a lot in civil cases, and people care less about those lies because no one's going to jail, so they think it's not problematic. I had a company in this case just 2 years ago. They doubled the witness's salary from 60, well, more than doubled. It was 60-something to $150,000 between the time suit was filed and we took her deposition. With an associate's degree, okay? 60 to 150. She's the head of HR. Really. So, yeah, right place at the right time. But my point is, you want to separate out the criminal cases. It's not. It happens straight across the board in everything, and that's why you gotta be careful, because we can say, oh, I won't do this, I won't do that. I've seen as much cheating in civil cases as I've ever saw in criminal cases. Again, that's sort of the criminal cases. We know who the bad guy's supposed to be. Civil cases, the bad guy could be everywhere. And that really is true. So we'll come. We have other questions to come back to this topic at other times. I just want you to start to think about how this fits in, and hopefully Jonathan's not going to say, "Well, I'm done with law school because I'm not living out of a cardboard box." But you don't have to live out of a cardboard box, but you do have to have a sense of what it is you want to do with your law license, how you'll use those talents. And I've always thought, at least part of the reason I liked being a lawyer is there was some choice, but as Jim has already pointed out, but not always, especially early on, who I can work on behalf of, who gets the benefit of my talents. Jim's right, early on you don't have that same choice when you're working for someone else. And you don't get the best cases. You get the cases oftentimes no one else wants. And so these are ones that oftentimes no one else wants, are the ones that are a little more suspect and a little more troubled, because no one likes to see the Board of Bar Overseers sending them letters saying, maybe we should talk. Because at the end of the day, that's the other problem, and we're going to see another case with other issues like this. You don't want to get swept into your client's own problems, and they will involve you in it, whether it's civil or potentially criminal litigation. And especially, and there are lawyers that have had this problem, is that if you're going to tell them how to say things that aren't accurate and look for other information that isn't real, then trust me, they're going to roll over on you, and you're the first person going under the bus. So all your work in law school and all the books you read, you're going to have short need for them at a relatively early point. So let's talk about the where'd it go now? The Little League case. So our next case is Clinton versus Nagy, and again we've got another request for injunctive relief. And what we're looking at here, the plaintiff files suit. What is it that the plaintiff wants here? She wants to play football with the boys. Why can't she play football with the boys? She's a girl. And so in 1974, little girls were considered too frail to play football with the boys. Right?
Yes.
So what does she do? She sues. Where?
District court.
in Ohio, right? So how does she get, what gives her the basis to go to federal district court anyway?
It's a constitutional violation.
Right? She's saying that there's a constitutional violation, so she can go to federal court on subject matter jurisdiction. She's got a statutory violation, 42 U.S.C. 1983, violation of her civil rights. And she wants to enjoin the defendants from depriving her of the recreational opportunities because of her sex, and she wants a declaratory judgment. What's a declaratory judgment?
You want the court to give you the relief that you're just asking them to give you the relief of what you're asking for, basically.
What's that mean? The relief of what you're asking for.
It's declared right there, then you do the trial.
Yeah, declaratory judgment declares the rights and obligations of the parties to a real or threatened controversy. So you've got to have a problem that the court can address. And the problem with declaratory judgments is the window's relatively narrow, because if you don't have a sufficiently ripe controversy, there's nothing to issue a declaratory judgment about determining the rights and obligations of the parties. If you wait too long, such that there's already been the injury, then the argument is you should just be suing for those violations, and you can't get then a declaratory judgment. Declaratory judgment is a classic form of equitable relief, which again means that it's only awarded or denied by the judge. There's no right to a jury trial in any action of an equitable nature. And so you're asking the court to issue a declaration of the parties' rights and responsibilities as a result of whatever the controversy before them is. And so here in this case, the matter's heard on a Friday, November 1st, 1974. The court grants plaintiff's motion for a TRO, and then explains in greater detail below. They had sought a waiver for her, and she had signed, I guess, the standard agreements. Medical service agreement, right, of all the players, so that she could participate. That was on September 28th. And then at the end of middle of October, the mother was told that the daughter could not play because that was the law. She had hoped to be able to play, and the only way she was going to play this season was if she was successful then in obtaining injunctive relief. So what is the actual order she wants? Oh shit, hold on, I gotta take this call.
You guys, Rachel there, please? Rachel? She's the news director. Okay. Rachel? Michael Coyne, how are you? I didn't. I called back on this number. She told me. I can be there at 9:30. What time do you actually need me there? What's that? Oh, sure. I'll be there around 9. Okay, Rachel. Thanks. Bye-bye.
I'm sorry. So where were we? So she needs an injunction, and because she wants to play in these last two games, but she goes in on November 4th, right? No, heard on November 1st. She's seeking an injunction that will allow her to play just the last 2 days, November 2nd and November 9th. Is she successful in obtaining the injunction? She is, right? Go ahead.
Question, how does she have standing? Because it's kind of speculative that she'll even be able to play in that position or play in the games at all so late in the season.
I was going to address that. Well, they said that the injunction is just to allow her to stand on the field, whether or not she has the requisite skills to actually play the game's another story. And I'd like to know if she actually played in the game.
Well, you can look that up for us, Charlie. Because there's actually a couple good related questions to both those issues here. When we have cases like this, because actually Doug Flutie sued the New Jersey Generals in sort of a similar fashion. He was just seeking to get the specific performance of his contract. And any time we have individuals who are looking to either perform or to be part of the team and things like this, the court can't order them to perform, to play football, or to do certain, to actually put her on the field. What they can do, and this is why you've got to be careful with the order you seek, what they can do is make her part of the team. But at the end of the day, whether the coach chooses to play her or not is a different story. For the professional employment situations, and we're going to see one later on with Vanessa Redgrave, you might be getting money and nothing else, because what you've got is a breach of contract perhaps, but when it comes down to saying someone gets to play or someone gets to perform as they had expected, there's almost no way to properly supervise that type of order. She gets to play. How much? How little? No matter what happens there, she is going to be angry and feel that, she potentially is going to be angry and feel that the defendant has violated the order. Now we're back again, and the court is involved, in essence, in micromanaging these types of orders. You just can't do that, and the court's not going to be involved with it. It actually becomes a big problem when we start to look at personal services contracts and individuals who are looking for an order like this. She just simply gets on the team. Coach might still choose not to play her. I would think he does so at some peril, but the fact is that at the end of the day, the coach can say, well, she still wasn't one of my best linemen, or whatever position she plays, and so she doesn't play. She gets to be part of the team, at least for the period the TRO is in effect. And that's what I think is kind of interesting here that I want you to look at, because the TRO is received on November 1st, and then the next 2 games are November 2nd and 9th. When does the court set it down for any further hearing here?
November 26th.
November 26th. This TRO is going to finish the case, because next year she'll be 13, she won't be eligible any longer. What they've done by way of timing, and this is important to start to think about with respect to TROs and the like, and for you to understand whether it's the TRO or the prelim. Oftentimes when we seek these types of orders, this may be the end of the case. And so whether you're going forward or whether you're opposing it, you've got to be prepared to do both in a relatively quick and short order, because the fact is, if she gets what she wants at this TRO stage, there is nothing else that she needs other than perhaps the money for her previous injuries. But that injunction won't stay in effect beyond the time period that she's eligible to play, which are only the next 2 games. What they've done is they've staged the timing of the order to get exactly what they want, and the court has done so in almost a bulletproof fashion, because by the time they have any real opportunity to appeal it, the issue really, for all intents and purposes, is likely moot. And so it's an interesting way to use the injunction process to really get what they want and make any further likely pursuit of that pretty much unnecessary, because the last order then is plaintiff's motion for PI is to be consolidated with a hearing on the merits of her claim for permanent injunctive and declaratory relief on November 26, 74 at 1:30. By the time November 26 comes around, she would have either played or not played, and so the likelihood of any need for a further hearing, certainly with respect to preliminary injunction, is moot. And the likelihood is that her 1983 action may still go forward for the money damages part of it. But at this point, what they've done is they've timed the order to get themselves everything they need. And it's an interesting way the judge has set it up as well, because this should be the end of it at some point, just because they were able to get the injunction. Did you get to play, Charlie, or not?
I couldn't find it.
Question? Go ahead.
It said in the beginning the coach was on her side, though, so I'm sure Trey put her for a couple of plays.
Coach wants to win. Maybe she's a player, right? Could this have been a class action case?
Yes.
Right? On behalf of all the other girls that might have wanted to play football and were denied on the basis of their gender. I think that's true, too. I don't know whether we would have had, again, I'm sure the defendant in part would have said, well, there aren't others that want to, or the class is not sufficiently large. But my guess is that there's more than one that feels that because of their gender they are being discriminated against improperly. Questions on the case? I think it's an interesting case from the procedure and the way they stage it more than anything else. And the way the judge stages it so that the process is used to benefit the plaintiffs and get them what they need without really likely a problem then that's eligible for review on appeal. So the last case we have for this section is Norwalk Corps versus the Norwalk Board of Education. They're seeking a preliminary injunction in this class, in a class action, and what they want is that the trial on the action on the merits be consolidated with the hearing on the motion for a PI. Which, if that happens, that means everything happens really very, very quickly. In order to proceed as a class action, what must you have?
All members have to be heard by the same, whatever you're going after. And then you got to be represented by a person who can adequately and represent you.
Class representative must adequately represent the interests of the class.
They must have an injury that's similar. I don't know the exact words. A similar injury that they must all be experiencing this. A similar injury that the class action leaders asserted. That's terrible, terrible. I'll figure it out.
What do you got?
Typicality, numerosity, adequacy. And there's two more, somebody else.
Typicality, adequacy, numerosity. What do you got?
Manageability.
Manageability. Did you say commonality?
Commonality.
Great, right? Listen, the test for a class action is a group too numerous for joinder, who have been injured as a result of common questions of law of fact, right? A group too numerous for joinder, who have been injured as a result of common questions of law or fact. So, and we've talked about, we look at what I call the 5Y test. Numerosity, right? Group too numerous for joinder. Commonality, suffering from common questions of law of fact. Typicality, that the claim of the class representative must be typical of the claims advanced by the class members. Adequacy, or adequately, depending on which word you want to use, that the class representative and their representative must be able to adequately represent the interests of the class. And then finally, the manageability is the fifth factor that the court now looks at after the Walmart case. And what they're saying is this a superior way to proceed? Is the class action actually manageable if we should proceed in this fashion? And if it is, and you can satisfy those 5 Ys, then the court can certify it as a class action. And until they certify it as a class action, it's really just brought on behalf of individuals, and it could be one individual, it could be a few. And so then, under those circumstances, the case can move forward as a class action. So here, who are the class members in this case? Who would be the purported class?
The kids from Nathaniel High School.
Say what?
The kids from the school that's closing.
Okay. The kids from the school that's closing, and what is it that they want?
To keep your school open so they have to bus to the white school.
So that, say again, Everald, I'm sorry?
To keep their school open so they have to do busing to the white school.
So to keep the schools open so that they wouldn't be so that there'd be more than one group bust, right? And at least in part, they feel that that would be significantly better than all of the children sitting, only the black children sitting in the bus all day. What's this laches? It says the board, in opposition to the instant motion, accuses plaintiffs of laches. Unreasonable delay.
Prejudice.
In asserting your rights.
Sitting on
Cause prejudice.
That causes prejudice to the other side, right? Laches is an unreasonable delay in asserting your rights that causes prejudice to the other side. It's different from statute of limitations, because statute of limitations is a definitive period in which the action must be brought or is lost, where laches, because generally it's an ongoing violation, it isn't likely to have a statute of limitations problem, but it still means that you've sat on your rights too long, in essence, that you've unreasonably delayed asserting suit, and therefore it's caused prejudice to the other side. And what they said here is that the plaintiffs have been aware of the board's intention to discontinue the kindergarten program at the Eli since May, and then didn't do anything till, when is this suit filed? It's right before the start of school, right?
Yeah.
I don't know where the date. I thought we had a date. Okay, I don't see it here now. And so the children, nonetheless, are asserting that they don't have an adequate remedy at law, that they do have a likelihood of success in the merits, that they will suffer immediate, irreparable injury as a result of this matter if it goes forward along these lines. And what they're looking for is the injunctive relief, so that, because as they see it, the harm to them is significantly greater than the harm to the other side if the injunction is granted. Public policy concerns, one could probably argue on either way that there's some level of public policy at work here with respect to whether the injunction should issue or not. Are they successful in getting the TRO?
No.
No, right? And again, just because you don't get the TRO doesn't mean that's the end of it. Because the fact is that there's three different stages when we look at it. One is a TRO, the next stage is called a preliminary injunction, and then the third is a permanent injunction. And oftentimes the TRO and the prelim, as you see here, this TRO is dated September 4th, 68. That's where the date is. It's on the very first page. And the preliminary injunction then is dated September 17th, 68. Actually, this is a motion to intervene as well in the class action. And I think this is when, shortly thereafter, they also set it down for the question of preliminary injunction as well. Oftentimes, those actions could be days or weeks and not months apart from one another with respect to pursuing the similar type of order where one wants to actually have the court require the party to do or not do something. They lost the TRO in this case, and what they did is the court ordered a consolidation with the trial on the merits with the hearing on the preliminary injunction. And the reason I started these out here is like this is I really need you to understand, oftentimes in civil cases we think that we have years to prepare. When injunctive relief is involved, you may be going to trial virtually like that. I've tried cases on preliminary injunctions that are virtually 2 months old. And so again, it says a couple things that you should be aware of. A, if injunctive relief is one of the remedies you're thinking you might need, then you really need to do prep in advance, not just sort of cursorily satisfy Rule 11. You need to have your ducks in order. You need to know who your witnesses are. You need to know what your documents are and where the foundation will come from if you have to go to trial quickly to offer those documents. You need to really think about how I can be successful with this case if the court forces me to go to trial on the preliminary injunction. At the same time, if you're defending the case, you have even a shorter window to do it, because at least the plaintiff gets to dictate when they file the suit. Once suit is filed, if the court consolidates it on something like this, you as the defendant may have at best weeks to marshal your defense, having done a full investigation for all your assets and everything, all the evidence that supports it and everything else. So you've got if the client comes in with these documents and wants you to defend, and there's request for injunctive relief, you've got to think about how much money quickly this case will involve. You can't undersell it at the outset, because in 2 months' time you might go through $10, $20, $30, $40, $50,000 worth of time. If the court consolidates it that quickly, hopefully you have partners or others to assist you on the other cases you might have. But you might be working some pretty long hours getting this case ready pretty quickly. And so that should be a consideration, is how much you're going to get out of it, and whether in fact these people can pay for what's needed to ramp up very, very quickly. And the other part of it is there a sufficiently meritorious defense that you will likely be able to marshal in short order? Where are these witnesses? Where are the evidence? And not just where, you may want to talk to them, you may want to see the evidence before you ever agree to actually represent them. Because with a TRO and a prelim, you may be running in and out of court very quickly in a very short order, and if they consolidate it with the hearing on the merits, you better be prepared to try the case, perhaps in as short as 6 weeks. That's a lot. That's a lot to do in a relatively short period of time. So I wanted you to see these cases because it is not that uncommon that the time frame when TROs and preliminary injunctions are sought is so compressed, it's so different than the typical civil case, that this is something you have to really think about, both in taking on the case and in preparing the case very, very quickly. Obviously, neither of these cases likely were bringing in fresh attorneys. They likely all had some history with respect to this case and knew what was likely involved. You don't always know when someone wants to enforce a non-compete or break a non-compete, or you've got businesses competing and using each other's slogans or using each other's intellectual property. Sometimes those cases will ramp up incredibly quickly, especially if there is situations about confidential information or trade secrets involved. That has to come to fruition very quickly. So I wanted you to see and carefully start to think about how that process is very, very different from our typical civil cases. Questions on the case? Yep.
I just have a question about the injunction.
Yep.
You mentioned the other day you had the DNA example of security. Now, is that for all the time that somebody brings an injunction against someone? Does that occur all the time?
It should. When an injunction is sought under Rule 65, and we've got actually, I think, 2 full weeks where we look at the bond and the bond process. So not to take all the excitement out of it, but the Rule 65 requires a bond. We're going to see, as we look at jurisdictions, the court has a great deal of discretion in setting the bond, but there should be a bond. What happens oftentimes is people don't argue for it. And they don't, even if they argue for it, they don't present sufficient evidence to justify the value of the bond. And it's a significant obstacle, potentially at times, in order to get the injunctive relief if that bond is sufficiently high. So we're going to approach it as it's another means of trying to defeat requests for injunctive relief. And again, like with all of law, but especially in these injunctive relief situations, but it really, the issue pervades all of law. You don't ask for it, you don't get it. You don't ask for hearing, you don't get it. You don't ask for the bond, you don't get it. You don't ask for $1 million, you don't get it. You can't be afraid to ask, and especially where you're entitled to. You don't ask for an evidentiary hearing, you're not going to get it. You're entitled to a bond. The court has some discretion, but frankly, if you don't ask for it, if you don't present the information that says why you need a sufficient one, then the likelihood is they're going to issue what we call a nominal bond, which might be $5 or even $50. But obviously, that's not going to cover anyone's costs if that injunction is later found to be improper. No bond, huh?
Well, because I was thinking, when you had the Guinea age example, and I can see, obviously, Celtics could put up a bond without a problem. But then you look at these other people who have to come in and bring an injunction against someone. How do they come up with that?
I think it was by recollection, it was the Blue Jays seeking to enjoin the Celtics, so they would have had to post the bond. Okay. Actually seeking to enjoin Ainge, and the bond he wanted was in excess of $300,000 or something. And obviously the Blue Jays should be able to do it as well. But back then, I forget what year it was a pretty significant bond.
81.
So
Was it that?
but the bond is a way of defeating potentially the claim. I had a client one time, he wanted to file a suit against the city of Boston on a zoning decision, and as part of Boston zoning laws, if you're going to file a suit on one of the decisions, you can file a suit, but the court also can establish a bond for the entire costs of the defense of the case. And if then the case is lost, that bond is forfeited, you have to pay the entire cost of the city of Boston's defense in that matter. We had the case all ready to go. He got cold feet on the weekend because he thought that the bond would be excessive and that he could lose everything he has, depending on how long the case took. The bond can be used to defeat either access to the courts in that case or to defeat the imposition of the TRO or the preliminary injunction. Okay? Okay. See you next time.
They can lose the bond? No, not really. Posting the bond, can we lose the bond? I mean,
not unless the injunction was improperly granted. What did Holder say about Sonev and the death penalty today?